My name is Mel Herzberg, and I'm the president of American Community Management. And thank you for coming today. Such a beautiful day. Should be a good pool day, I hope. And but it's going to be a better pool day tomorrow. So we have two very distinguished speakers with us this afternoon. One from Rees Broome and one from Whiteford Taylor. And I have been given, I thought, which I don't have, their resumes. Ursula is here from Rees Broome, and Ray is here from Whiteford Taylor, and they're going to talk about the legislative issues that passed this year and some of the court decisions recently that have come down that impact community associations and management companies, and then we will talk about not collections. We're not going to talk about collections there, are we?
Just a couple of cases.
No, a couple of cases. We also have our head of the accounting department here, vice president of our accounting department is here. Frederick is our new vice president, and Mr. Jones, and he's going to talk about an upcoming seminar for a few minutes. So I want to introduce to you our speakers, and I think you're really going to enjoy it. I've heard both of these individuals talk on a number of occasions. I went to Ocean City, I think, to hear Ray talk about what were we talking about? Reserve studies. That was fascinating. Ocean City in the wintertime talking about reserve studies is a good thing to do. So with that, I'd like to bring Frederick up. Frederick, if you could give us a spiel here on what's going to happen with the accounting process.
Okay. Good afternoon, everyone. I'd like to welcome you again. We're going to have a financial and budget seminar next month. It's going to be on Wednesday, August 23rd. And if you guys attended last year, it's probably going to be some of the similar topics. So basically, we're going to cover how to analyze your financials, interpret your financials, and also cover many cash management components of the financial. I feel the better that you guys understand the financial, it will help you in the budget process. But I want to kind of cater this upcoming seminar to your interests and your concerns and things you might want to learn more about. So we have a questionnaire that if you haven't received, you will receive. And I would like you to just spend some time and think on topics you would like to know about in terms of your financials and your budgets for the upcoming year in 2018. So that is how I feel that we'll get the most out of it. I want it to be engaging, but I'm also going to allot plenty of time for Q&A, and I'll stay after if any of you guys want to ask me questions one-on-one that's specific to your communities. We're here to help you, but we're also here to provide any information needed. And like I said, I understand that this is some information that you may have covered last year, but we want to make it a little bit more concise this year because I understand that you guys are volunteers and you stepped up as board members to help your community. So I want to make sure this is our seminar, not just me up in front of you guys, just speaking. I want it to be really valuable. And on that note, I thank you for your time, and I look forward to seeing everyone next month.
Is it going to be 4 to 6 again? The next one?
Yes.
Okay.
It's 4 to 6.
Yeah,
Okay.
yeah,
All right, our first speaker is Raymond B. Via Jr. He's a partner with Whiteford Taylor Preston, and he has had many years of experience in community association management. He practices in Maryland, District of Columbia, and Virginia.
Not Virginia,
Not Virginia.
just DC and Maryland.
Oh, that's good. All right, and Whiteford Taylor is a rather large law firm that have offices, I think, in
Baltimore, Columbia,
yeah.
Bethesda.
Big
etc.
organization, a big part of CAI. So and so is Ray
Absolutely.
teaches. I've attended some of his classes. So Ray, you want to enlighten us? I'd appreciate it.
Sure, thank you. And thank you all for coming. Mel, thank you for having me. I appreciate you coming. I think you're all here just for the air conditioning. But hopefully we can impart some good information to you. As Mel said, I'm the managing partner of our Maryland Community Association practice. I've been doing this for about 25 years, and if you've ever seen those farmers insurance commercials, I think I've seen it all, and I think we've pretty much done it all. I'll spare you the little jingle from the commercial, but you know, every time you think you've seen it all, every time you think you've done it all, you see something new. And that's the nature of our practice, and that's the nature of community associations. We've been involved with a lot of legislative activity over the years, And we've been involved in a lot of litigation matters that make law when these cases go up to the appellate courts. And on the legislative front, I served on the Maryland Legislative Action Committee for many, many years. And I can tell you that the legislature has occasionally made good law for community associations, but on most occasions they've done things that make us as practitioners kind of scratch our heads and say, why'd you do that? And it doesn't necessarily assist associations. I think the same is true with case law. Got a lot of appellate cases. Some have been helpful to the associations, some have not. So with that context in mind, I'm going to talk about three things. How the case law and the legislation has changed the game for us in community associations in the area of collections, in the area of fair housing, and particularly the HUD hostile housing environment regulations, which came out in October of last year and which are candidly very frightening. And then we're going to talk a little bit about electronic car charging stations and how that's kind of the future of associations in terms of having to allow those and how to navigate through that set of rules that will be coming. So with that in mind, I want to launch right in to the collection area. And in the collection area, we have this case, Elvetson Town Condominium Regime versus Rose. And this case went all the way up to the Court of Appeals of Maryland, the highest court in Maryland. It went through the Court of Special Appeals to get to the Court of Appeals. And this Court of Special Appeals is the intermediate court. You would think special would be highest, but no, it's not. It's the intermediate court, and the Court of Appeals heard the case recently and made a decision in June. And what this case says is that the association in this case tried to enforce a rule. And it's going to be important to understand the source of authority here. A rule that restricted an owner's privileges and rights in the condo property due to their failure to pay delinquent assessments. And what they did was take away those delinquent owners' rights to park in the condominium parking areas and to get a pool pass to use the pool and the clubhouse in the association. And of course, the owner challenged that and said, you don't have rulemaking authority. The rule itself is not the requisite authority for you to do what you're trying to do. And the trial court agreed with the owner. Went up, as I said, to the intermediate court, Court of Special Appeals. They agreed with the owner. And the Court of Appeals just recently agreed with the owner as well. So what we have is a situation where the court has said there's a hierarchy of the documents, the authority in the documents. This is very important. The declaration for a condominium and for an HOA is the highest form of authority. It's recorded among the land records. It's very, very hard to amend. Whatever's in there is pretty much gospel. It's like the constitution of the association. Then you have the bylaws in a condominium. They're also recorded, also very hard to amend. The court's going to give them great deference. But rules are made by whom? Board of Directors. And this year's board can make a rule. Next year's board can change that. So that's given the least amount of credence by a court. And in this case, the declaration, which is the Constitution, right? It gives the owners the right, the easement rights in all the common property of the association. They have property rights that are in the declaration. So if you try to create a rule that extinguished those property rights, the court said, you don't have the authority to do that. And they were right. And I believe they're right. Now, that works a hardship on associations, doesn't it? Because withholding pool passes, it's a pretty good way to get the money. But this is what the court has said. And interestingly, it bootstraps onto a case from, it's like 20 years ago now. It's kind of frightening. But it was a case in Timonium, Maryland, the Ridgely condominium case. And in that case, it was a mixed-use condominium. Most of it was residential, but the first floor was retail and office. And so the residential people said, you know what? We're tired of all this traffic coming through our lobby. We're rehabbing the lobby. We're doing chandeliers. We're doing marble. It's going to be beautiful. We don't want all this foot traffic from the stores in our beautiful new lobby. They're going to have to go around and walk through where the trash cans and the vermin are, whatever, to get to the stores. Now, of course, the commercial people were also owners in the condominium too, right? And they had the same kind of property rights as those who were in the residential. So same exact scenario. passed a rule, owners challenged it, they, after the fact, amended the bylaws, they continued to challenge it, and the court said the only way you can do this, the only way you can take away these property rights is to amend the declaration. So this case is consistent with that prior case, and what it's about is the authority of the board. What authority do you have, and where does it spring from? Does it spring from the Condo Act, which is the highest form? Does it spring from the declaration? Does it spring from the bylaws? Is it merely a rule created by the association's board of directors? Now, all of you, I hope, in your communities have a collection policy. Does everybody have a collection policy? I see a lot of heads nodding. All right, that's a good thing. But in your collection policy, you may have some language that says we have non-economic remedies against our owners, i.e. we can take away your pool passes. You don't pay. That's probably not going to fly anymore. So you're going to want to go back to your communities and look at your collection policies to see what they say regarding non-economic remedies. You're never going to be able to take away parking, and at this point, you're not going to be able to take away pool passes because the highest court in Maryland has spoken on that.
So if you have it in your bylaws that if you are in arrears and your condo fees, it states that if you are in arrears for X number of months, you will lose
Yeah,
privileges.
this decision trumps whatever's in your docs,
Even if it's in your bylaws.
even if it's in your bylaws. And you remember, how many of you are old enough to, I should say old enough, how many of you remember when they passed the Federal Communications Act in 1996, and it said, it basically said you can have a satellite dish no matter what your documents say, right? Your documents say no antennas. Well, the federal law trumped that, and this case is going to trump what's in your bylaw.
I represent an HOA, not a condo, individual homes, and we have one person in this case who, when the accountant's gone to the attorney, it's the second time she's gone to the attorney. We include in our HOA fees trash pickup once a week. Are you saying that you can have her trash pickup once a week?
This case doesn't deal with trash pickup, and you're also in an HOA and not a condo. So you raised a couple of very interesting questions. And I had a talk with Mel about this earlier today. This case deals with condos, but it doesn't specifically, none of the verbiage of the opinion talks about HOAs. It seems like, though, it would be kind of analogous with respect to parking and with respect to pool passes. The idea of trash pickup really wasn't discussed. I think you could, I hate the lawyer saying you could argue it both ways, but I think you probably could. I don't know, you have any thoughts on that?
I mean, I think you're right. You can argue either way, but if you don't pick up the trash, then it's just going to stay out there.
Well, right.
And now you have the problem.
There's
So
a
I'm not sure
practical, there's a practical aspect to that too. We should pick up the trash. But you've raised a very good question, how this case is going to be interpreted going forward in terms of other services that associations provide, and the question about HOAs. Those are both good questions.
Going back to the antennas, if you've got a common roof, which we have, can they put in do they have the legal right to put an antenna on the common roof, which is above that?
Well, it depends on what your documents say. But a lot of times associations put the antennas on a mast that's above the roof. I don't want to get into that one because that's a separate seminar and I got to let the cover.
Well, let me ask the question, because the young lady made a point that she said, my bylaws prohibit or allow us to take away services. And are you distinguishing between bylaws
Yeah,
and the declaration?
when I said that, I think the opinion, and Anthony has the opinion, I'm going to put him on the spot. I think it may say, unless your documents otherwise provide. Now, if it... Okay, thank you. It says unless the here's the lady. Unless the declaration, there's this lady. Unless the declaration otherwise provides. So the bylaws aren't going to quite get it done. And the reason for that is what I said earlier, the declaration is the constitution of the
The problem we
association.
have with a lot of the declarations and the bylaws, that at least in our community, there's 8 buildings. And then there's one, this lawyer that drew up the bylaws and did the declaration says one thing on one part and absolutely.
I've never
opposite
seen that
on the
before.
other.
How could that possibly happen?
I don't know, but, a common person usually couldn't pick it up. And that's why I asked that question, because it's.
I think they were very clear that the declaration is the only way out of this.
Yeah, no, and that's right. Just to kind of close the loop on that case, it's got to be the declaration. And the declaration is, as you all know, if you've ever tried, very hard to amend. But sometimes, and we'll talk a little bit about amending documents. The good news is the Assembly, General Assembly also made it a little bit easier to amend documents, and we'll get to that in just a moment. In fact, I'll get to that now. But the one takeaway practically is take a look at your existing collection policies. Because if your existing collection policies talk about non-economic remedies and sanctions, which include pool passes, which they frequently do, that's not going to cut it. So let me kind of segue into the amendment of documents.
Can everyone see that okay?
And hopefully I don't screw this up. But
No, we can-
I've done
we
it
can
twice
dim the
successfully.
lights over top. That's fine.
All right. So this is, you remember when I first started, I said most of the time the legislature doesn't do anything good for condos or HOAs, which is true over the course of many years. But this is a good one. And in this case, they said the threshold percentage of affirmative votes to amend the bylaws of a condo or the declaration of the HOA has been reduced to 60% statutorily. Okay, that's a good thing. And it has to be 60% of people who are in good standing. Good standing means you're not more than 90 days delinquent. So the previous minimum standard to amend was, of course, 2/3 majority, and the number of declarations for HOAs were at 75%. So this is a good thing. It makes it a little bit easier for associations, particularly older associations, to amend outdated documents. Because I don't know, many of you may have declarations and bylaws that were written in the 1980s or even earlier. And there's a lot in there that is not particularly applicable anymore. And a lot of it, as this lady said, you've got conflicts between the declaration and the bylaws, and you want to try to clean that up. Now it's a little bit easier to clean that up.
I think many years ago, that board was told that in order to change the declaration of bylaws, it would need the approval, not necessarily of the people who believe they own the home, but the
Mortgagees, yeah, right.
Is that accurate?
This doesn't speak to the mortgagee requirement. If the mortgagee requirement is in your documents, I think it's still there. So, yeah,
If it's not in the document?
then it's not there. A lot of documents say if you're going to make a material amendment, and what does material mean? Well, it's kind of the Lawyers Relief Act. What's material? We know certain things that are material, but it's a bit of guesswork. But if the documents say you have to get mortgagee approval, then you're going to have to get mortgagee approval.
If it's silent about that?
If it's silent about that, say you don't.
And then we just need the
Then you just need what,
people who
yeah,
live there and own
right.
the home.
And by the way, if it does, you can amend it out with 60%. So, and by the way, in a condo, if the mortgagees within 60 days don't respond, you send them a notice saying, we're going to amend our documents. Please let us know whether you consent or object. In 60 days, if they don't come back, the Condo Act says that's considered an
What about
approval.
HOA?
It's HOA doesn't, the statute doesn't speak to
So-
it. You have to look to your documents.
Okay, but if the document doesn't say anything about the bank, the mortgage holder, that would be the people who.
That's
live
just,
there.
it's the folks who live there.
I have another question. I just realized you have up there bylaws of the condemnation and declaration of a homeowners association. Our condo has both a declaration and a bylaw.
Well, this speaks to the bylaws of a condo and the declaration of an HOA.
But
It
what
doesn't
about the
speak to the declaration of a condo. You're right.
Yeah, so, we have both documents.
It doesn't speak to that. Whatever's still in your condo declaration is what it is. Because most people are amending the bylaws of a condo are the operational, that's where everything pretty much is loaded into.
This has come down from some court as far as
This is legislation.
trumping anything that we might have.
Sorry?
So this has come down, okay, so this is legislation.
Yeah, this
so
is-
It overrides anything we might have.
Correct. That is
Just
correct.
like the previous.
Yeah, exactly.
Okay.
All right, so the next thing I was going to do is talk a little bit about the foreclosure stuff, but I don't want to,
I don't know, you just talked about my part on the, amending every document.
oh dear. All right, so as not to steal Ursula's thunder, we are going to kind of go by much of this. I'm just going to talk about one piece of this. And that is something that I bet a lot of you have some experience with. And again, I'll let Ursula fill in the blanks, but I just want to tease it a little bit. And that is, how many of you have had vacant property in your community where you think it's been foreclosed on, you know it's been foreclosed on, but it just sits there? And you get the broken windows, and you've got the door. And yeah, sometimes that's right. Sometimes you can have squatters. This is a piece of legislation that's designed to remedy that, and it allows an expedited sale and foreclosure of abandoned property. But that's all I'm going to say on that. I want her to fill in the blanks. Like I said, I just wanted to tease that. That's a good thing for associations, particularly for those of you who've had to deal with the eyesore property that just sits there in your community.
It doesn't help you though in terms of having any rights to collect it. All of the sales price wipes out only the mortgage.
Well, yeah, I mean, I can't give you an entire bouquet of sunshine, but I can give you at least that. And there's also, just since you raised the question, or the point, there is a fairly recent Court of Appeals case in Maryland that says the foreclosing, typically lender, the foreclosing party is liable for assessments from the date that the hammer falls at the sale, not from the date that they transfer to a third party, which can be 6 months, 12 months, 18 months later. So they're liable from the date of the sale, and Maryland law is very clear on that point.
You have an assistant identification and collection of delinquent assessments. Are you going to cover that, or is she going to cover it?
I'm sorry, I didn't hear the first part of your
The
question.
last, remove it.
No, I'm going to, I think she's going to take care of that. Oh, but you're talking about the last slide.
Go back one.
Or you're talking about this one?
Previous.
The previous slide. All right, let me go back. You're testing my technological prowess here.
That last sentence on that.
Well, yeah, this is exactly why it's good.
Okay, so somebody going to cover how?
Yeah, I think she's, yes.
Or you can just cover the process one.
No, I feel kind of bad that I did that. We'll make sure we get through it.
You said that it's effective the date of the sale. How do you find that out when they fail to file? with
Well,
the staff?
there's some notice requirements that just came out as in additional legislation, which Ursula will talk about, yeah. But they've helped us in that regard, too, in terms of getting notice of when the lender took title, or when they took equitable title when the hammer fell at the sale.
So will they be required to file with SDAP sooner? And
Well, there's a notice requirement now to the associations. All right. So this is a situation that I hope you've never had, but again, a little bit of a help for associations. If the association is going to voluntarily sell property, they have to give notice to the board is going to voluntarily sell property to an adjacent community, or there's some kind of deal with state highway or whatever it might be. Then they have to give 30 days notice to the individual owners within the community. And it also comes up in context of like tax sales or utility companies selling because utility payments haven't been made. There has to be notice to the membership within 30 days, with the presumption being that if the board is a rogue board, or a board is checked out and isn't doing what they're supposed to be doing, you give notice to the owners and maybe they can rally and fix it, so that you don't lose property by virtue of this, the board not doing what they're supposed to be doing.
Colin, when you say property, are you talking about real property, or are you talking?
I'm talking about real estate.
You're not talking about.
No, I'm talking about real estate. And again, these are the procedural requirements: written notice, posting a sign, like a zoning sign. You've seen those signs where in front of a vacant field where it says we're about to build a shopping center. Those kind of signs.
Does it specify the kind of communication? Because if they're no longer on their property and you don't know their polling address?
Are you talking about for the owners? Yeah, you just have to use the last known address.
Okay.
So yeah, I mean, it's just sort of like searching for the mortgagees, like this gentleman said. Somebody could have a mortgage on the land records and refied it 5 times with a note, and you would never know who you just have to use your best efforts, due diligence, to take care of that. All right, you're going to do resale inspections. Are you going to do the rear view mirror inspections?
No.
You got that one in there? All right. This is kind of an interesting one. Beginning October 1st, the driver may not drive a vehicle on a highway with any object, material, or obstruction hanging from the rearview mirror that interferes with the clear view of the driver through the windshield. Why is that important? Because a lot of associations have hang tags to identify that people with those vehicles can park in the lot. Now, you can leave it on your vehicle when you're in the lot, but you should know that when you're driving, that you can get pulled over by maintaining your ABC Community Association Inc. hang tag. Now, I don't believe that applies to handicap tags, but I'll defer to you. Does it apply? All right. Well, it does. All right. So everybody is now, consider yourself warned. Take those hang tags down when you're driving.
Do they give a specific size? Because some of them are pretty small.
I don't think it matters. The good go with the bad.
And what about the inspection? I think it's interesting.
I'm going to she's going to cover that. And I think that's the last time I inadvertently poached. All right, now let's talk a little bit about proposed legislation that didn't pass, because this is very instructive sometimes about what's being presented to the legislators and how they're thinking. Ban on tobacco smoking in a condo unit or townhome, you can probably anticipate that went down in flames. But that is the wave of the future. There are states out there that have banned smoking in fee simple property by legislation, Massachusetts being one. And the issue has been raised before in Maryland in a case called the Schumann case. And in that case, the court held that smoking is not a quote-unquote, inside the fee simple property of the owner, is not a nuisance under the governing documents. You've all seen governing documents, that you all have them. And they have that list of use restrictions, no boats in the driveway, clotheslines, whatever it might be. And at the very end, there's this garbage can that says no nuisances. You can't do something that's going to disrupt your neighbor's quiet enjoyment, anything that raises the insurance, whatever it might say. There's always that nuisance provision at the very end of your documents. And the court held that smoking inside the unit is not a nuisance. It doesn't rise to that level of being a nuisance. If it's in the common areas or the common elements of a condo, yes, the association can control that. But as it stands now, today, as I stand before you, that inside the unit, it is not considered a nuisance. So it is not something that the association has the authority to prohibit by rule or anything else.
But it is in the bylaws.
Now, all right, here's an interesting question. I have a client, we have a case going right now, and it's not in the bylaws, but it's in rules and regs, which are recorded. They recorded the rules and regs in the land records, which mean they run with the land. They still have that lower level of authority, right? But they run with the land. And they classify a nuisance as noxious or offensive odors and all kinds of, it goes well beyond the scope of most nuisance provisions. And so the plaintiff, who is a person who has a tenant that is objecting to the smoking of another owner adjacent to her, is saying, this, my friends, is a nuisance. And because we have this good language, we're going to take this all the way up, and we're going to get the court to decide to the contrary, that based on this language, smoking's a nuisance. Now, we haven't gotten that far yet. I hope we get the case settled, because I don't necessarily want to be the champion of smokers in Maryland. But, and I don't mean that offensively for any of you who smoke, but it's coming. The day is coming where I think that's going to be revisited anyway in the courts. And so we'll just have to wait and see. Right now, the law of the land is smoking in a unit is not a nuisance, and this legislation died. State licensing system for community managers. For those of you who are managers in the room, that went down in flames too. It was supposed to be through the Department of Labor, Licensing and Regulation. That didn't go anywhere. State registration of community associations. It was going to be, there's an organization called the CCOC in Montgomery County. This is going to be sort of a statewide way to track all associations, where they are, contact information, get them to pay a fee. That didn't go anywhere. Limitations on the enforcement of developer construction warranties. That was actually consumer friendly, because that was going to be a provision that said in new documents that developers create, they can't shorten the warranties, because you can do anything by contract, right? And a declaration and governing documents are a contract. And the Secretary of State's Office of Maryland, who approves these documents, well, has in the past taken documents that shorten those warranties or that change those warranties. And this bill was going to make it verboten to do that. It died. Requiring periodic replacement reserve studies, that's what we were all amped about when we were in Ocean City, and I was speaking to the group that Mel was part of. That died. We really thought that was going to go through, to require mandatory reserve studies for associations.
Find us a good organization and just have them
Ouch.
do it. I'm sorry.
And not terribly expensive either.
Are you talking about a good organization to lobby for it, or a good organization to do it?
Well, an organization knows what they're doing when they do it.
When they do the reserves, well, there's a lot of good ones out there. Afterwards, I'll give you some.
Sometimes they cover everything, but,
Well, hey, that's the old saying about SISO. You got to give them what they need. You give them the governing documents they figured out, but walk them around the community so that they understand what's common element and what's unit, et cetera. So, that we had high hopes for. Backyard gardens, that was a proposal not to allow associations to in any way limit somebody having a backyard garden. Don't have a whole lot of history on that one, but it didn't go anywhere. Seemed fairly reasonable. And then I'm going to talk now about limitations on electronic vehicle charging stations. That was Senate Bill 301. That was modeled after a California piece of legislation that just passed. And that, again, is the wave of the future. In 2020, there's going to be 4 million electric vehicles on the road. Some of them are electric and gas. Some of them are pure electric. But there's going to be a lot of them. I'm curious, in your communities, does anybody have the charging stations now? Okay, well, I may call
we
upon
had
that.
one in the first movie.
So let's talk about this for a second. I got to switch. So the proposed legislation was Senate Bill 301, and it was going to be applicable to condos and HOAs. And it basically stated that provisions in governing documents are void and unenforceable, which kind of interesting redundancy. If the provisions prohibit or unreasonably restrict the installation of recharging equipment in a unit owner's, this is where the important part is, in the unit owner's designated parking space included a deeded space, I own it, I got a deed to it, I pay taxes on it, an LCE parking space, limited common element, it's appurtenant to a unit, it has to be appurtenant to a unit, it can be transferred, but it can't exist by itself, it's appurtenant to a unit, or a parking space that is specifically designated for a particular owner, a common element space that someone's been assigned. So with respect to all of those, this legislation was going to say that reasonable restrictions could apply, and we'll talk about what those are. And if approval is required, use the same process for approval as you would for an architectural modification. Meaning you come to the board, say, here's what I want to do, here's a schematic of what I want to do, and then we talk about what the reasonable restrictions are and what the association can say, the hoops you have to jump through before we're going to say yes. So what are those hoops? The first thing you have to do is make sure that the installation is done properly. The installation has to be done pursuant to plans that are submitted to the association. It's going to have to be signed off on by by someone who's a certified professional, an electrician. The association's probably going to have an engineer involved who's going to opine on where they can be placed, the electrical current, whether that's sufficient, etc. You're also going to have I'll skip down to here, a written agreement that requires that the owner do all the maintenance. If there's required maintenance, in addition to the installation, if there's required maintenance, it's up to them. That'll be part of the written agreement. Indemnification and release. If in the installation process they damage the common elements, they damage someone else's Tesla, they inadvertently hurt someone, indemnification and release agreement, they have to sign, which indemnifies the association for whatever work they're doing there. Insurance, the association has to be a named insured on their HS6 policy. They're in a condominium or in an HOA in their homeowner's insurance policy. The association has the right to terminate if they're delinquent. And how do they become delinquent? Well, there's a number of ways they can become delinquent. But you have to figure out a way by which they pay for the electricity they use. So they got a separate meter. How many people are managers in the room? Okay. So you put in a separate meter, or you figure out a fee. If that's not practical or whatever, you have to figure out a fee that they pay monthly that approximates what you think the usage is or will be. So that's all part of the deal. And if they're not living up to that deal, then the association has the right to terminate. And then the association is going to create a formal policy, which is going to incorporate pretty much all of what's there, and the owner's going to have to jump through all these various hoops. Now, this bill failed, but I guarantee you it comes back next year. And I'd like to know, do you know why it failed? I don't.
Yeah, because it's bad legislation, that's why.
Well, okay, I mean, all right, no, I'm with you.
It's Elon Musk and General Motors who put this.
Okay, no, I understand.
And
but
it's all about selling automobiles that are electric.
it is.
And it's the same concept, that whole idea about negating the bylaws and the declaration that they were talking about with the radio antennas after 9/11. We all needed shortwave radios because of 9/11.
And that's actually a pretty good example.
Now, in the meantime, this whole process of charging cars is moving forward. There's nobody talking about putting electric charging stations on Hamilton Avenue in Baltimore City or in the middle of Columbia on any public streets. It's
Well, you
all
see them in
about
you see them in public parking
It's
garages.
just very irritating for all of us in this industry to all of a sudden find ourselves as if we're now going to be creating this. Remember, development rules were 1.5 parking spaces per unit. So now we're going to be dedicating parking.
All right, well, and that's a good point too, because when the developers develop the property, they say, we are going to create this community, and within this community, we're going to have X number of spaces
And now, of course,
per
they're taking
unit.
away our
So if
ability
you're
to-
taking away those spaces, yeah,
For-
that's a good
if we
point.
can't collect the fees for the parking
Right.
space, the court said we can't do that. So how are you going to stop somebody from
So
using
this is a
electric power?
persuasive case. You've just heard a persuasive case why it's bad legislation. The problem is, it's coming. And we're not going to be able to do a whole lot about it. So the best thing we can do is impose reasonable restrictions. And charging them for the maintenance, charging them fees. You could charge them an installation fee.
I think when you take somebody's property, they have the right to be unreasonable.
It's
And that
interesting, I
is-
have a gas run car, and nobody, I put gas in my car in my parking lot. There's no gas pump right there.
It just seems, it seems like a short, I mean, they're taking advantage of people who live in common interest communities. That's what's most irritating. The legislation has been offered up 2 years in a row.
Yeah, no.
And it's the same legislation. It was drafted in California by General Motors.
Oh, I didn't know that it came from General Motors in California, okay. All right, well, you're making a persuasive case. I'm just
I
telling you.
heard that on fake news.
It's, and for the record, I don't own an electric car. I'm just telling you, this is what I see.
Sign me up.
Have a question?
Yes.
You said that there are going to be 4 million cars on the road, electric cars. Are you talking about electric cars that you plug in, or electric cars?
I'm talking about,
or
that's a good question.
gas?
I'm talking about a mix of hybrids and purely electric cars just that you plug in. It's not going to be 4 million just that you plug in.
Okay, so what we're talking about then is trying to make associations go through all of this stuff for just a very, very tiny number of people in any one.
No, hybrid cars don't have to be plugged in. I mean, I don't think they do.
That's what I'm talking about, only the electric.
Only the plug-ins, yeah.
I mean, why can't a person just plug it into their own electricity?
Well, they don't have, I mean, they can't take their car up to their unit in a high-rise condo.
Oh, yeah, the garage is out.
No, don't put me in the position of defending electric cars, because that's beyond my pay grade. But I'm just telling you that the day is coming, and we have to be prepared for it. It's been introduced 2 years in a row. It's just like when we did the priority lien. Eventually, it's coming. Now, in that case, we were on the side of the angels, but it is going to be coming. So,
Well, give us a couple of years when they do pass the law anyway.
yeah.
What they do with the fire smoke detector.
But, I mean, you can see it happened in California, it happened in Colorado, it's happening all over. I mean, granted, whatever happens in California isn't necessarily a mandate for anybody else, but it's coming, and we just need to be prepared for
What's
it.
going to happen is like in our neighborhood, an owner shows up and says, I want to lay a cord across the sidewalk. We say, wait a minute, kids are riding on the sidewalk. Well, I'll put a cover over it. Little bitty kids are going to, they're going to trip over this.
I mean, there's all sorts of possible permutations, you're
They put
right.
it under the sidewalk. Well, who's going to pay for that? You're going to pay for
Well, that part is clear, they're going to pay for that. Whatever ultimate implementation is for installation, they're going to pay for it. All right, now that you're really riled up, let me get on to fair housing, because
If it's such a good
then you may
idea,
actually
they
start
should
throwing
require it in
chairs.
the development process. They should require charging stations and new development stations should require additional parking spaces to be provided in new development.
I agree with that. I absolutely
Not go out
agree
and
with that.
create parking.
That's a great point, because it does work, a real hardship on associations when they've budgeted for a certain number of spaces, they've got handicap spaces, there's a formula for the number of handicap spaces per regular spaces, so it does work a hardship on associations, and CAI is going to have to be pretty vigilant in trying
They've been
to...
pretty silent.
All right, well, like I said, if you thought that was bad, now we'll get to hostile housing environment.
It's really big.
And you may start throwing chairs, but don't throw it at me, I'm just a messenger. All right, so you're all familiar with the Fair Housing Act, I take it, or at least I hope you are. It has to do with discrimination in housing against persons of particular protected classes, race, gender, religion, familial status, in Maryland, marital status now,
There's another problem.
and of course handicap. So you have all these various categories of people who are in protected classes, and where we typically see the issues in homeowners associations and community associations is someone comes to the association to make a reasonable accommodation for, frequently it's like a seeing eye dog or an emotional support animal. That's a reasonable accommodation because we're in a no pet building, but because I have a particular disability, then I'm entitled to this reasonable accommodation. You're probably all familiar with that. The second piece would be reasonable modification. That means I need a ramp to get to my unit from my wheelchair. I need a curb cut in the sidewalk so I can get to my unit. And same drill, you go to the board of directors. The board of directors does a due diligence investigation. If there's appropriate medical documentation, then typically that's permitted. The person who's requesting it has to pay for it. So that's what we're used to seeing. But now, we have something entirely different. In October of 2016, HUD passed national legislation, this is all federal folks, that the hostile housing environment causes of action now exist. Now interestingly, when they made these rules, they said, well, this doesn't really create any new cause of action and not any additional liability for associations. To which I say words that I can't say, but it's like when you go to the dentist and he says, this isn't going to hurt at all. And you know it's really going to hurt. That's this. So the traditional analysis of neighbor versus neighbor disputes is what? Does the association typically get involved? It's not our problem. Unless it involves the entire community, health and safety issue, you guys got to work it out. And that's what we typically say. But the the hostile housing environment regulations have turned that idea on its head. And what it means is the association now is compelled to get involved in these cases in three separate areas. Quid pro quo harassment. That's a Latin phrase that we all learned in law school, and we have to throw it out every now and then. This for that. Unwelcome request or demand, liability or housing providers for its own conduct. That means the association would be directly liable if, say, for example, the on-site manager said, and I'm going to try to say this as delicately as I can, trading sexual favors, or you'll go on a date with me if I get you upgraded landscaping on your lot. That's as clean as I can make it. The cases are not quite that G-rated. But in any event, that's what that means. And the association's liable for that unwelcome conduct if they don't do something about it. You're going to ask, what are they supposed to do about it? I'll get to that. The liability for failing to take prompt corrective action for the conduct of its own employees or agents. A lot of times that means subcontractors. The lifeguard at the pool is harassing. The security guard is discriminating against families with children by harassing the children, not treating them the same as they treat the adults. Both of those instances are the association's liability, and they have to take prompt, capital P, corrective action for the conduct of its employees or agents. And then the final one is the worst one, liability for failing to take prompt corrective action for the conduct of a third party. That's where you've got one owner or resident harassing another owner or resident. And the association can be liable for that. Now, many years ago, there was a case in D.C. called the Carrollsburg condo case. And that was a famous case that everybody who's a practitioner knows about. And in that case, it was a terrible set of facts. Racial harassment by one owner against another in the common areas of a condominium, the laundry rooms, by the pool, in the clubhouse, and it was pretty horrible. And so the owner, the one who was being harassed, went to the association and said, please do something. And they actually sent a couple letters to the harasser. He didn't stop. And finally it came to litigation, and there was a motion for summary judgment, meaning the court decide this case on the law before we even get to trial. And to make a long story short, the case settled. The association had to buy this person's unit for $500,000. I'm sorry, buy the unit and pay her $500,000. And she moved away. But there was no guidance given because it didn't go to court. We didn't get an opinion regarding what actually constituted a hostile housing environment. Now HUD has told us, and the bar is set pretty low in terms of what this conduct can be. The new HUD rule defines hostile housing environment to mean unwelcome conduct, sufficiently severe or pervasive, to interfere with blah, blah, blah. And the conduct can be a single incident or several occurrences over time. So let's talk about a single incident. Someone comes to you and says, Joe harassed me at the pool. There's no witness. And you confront Joe, and he says, I didn't. You get in this he said, she said situation. What's the association supposed to do?
Question, what if the harassing party with minors being notified?
If the parents, I think that they're ultimately, their guardians are responsible for that. Look at my time.
It's
Yeah.
really very difficult as far as condominium is concerned, and like you're a president on the board. A lot of times you don't even know about this
Well,
stuff.
that's exactly right. So that's the main problem. You're liable even if you don't know about it. You're on constructive notice. You knew or you should have known. Now, go ahead.
We have a situation, and I don't, ethnic cooking, stinks in the hallway, guy gets
What'd you
mad.
say in the hallway?
In the common hall. Guy gets mad, sends a nasty letter to the guy with the food. We try to get the guy to open your windows, it's not. But nevertheless, I am now aware that this is happening. What am I supposed to do?
All right, that's where we're going.
That's all.
Now, by the way, before too much hysteria breaks out, the conduct has to be keyed to someone who's in a protected class. I have to say, you are making noise above my unit. You are making my life miserable because I am of a protected class, so race, gender, whatever it is. This isn't completely carte blanche, but I've got two cases like this already, and it's gotten ginned up. It's really two people that hate each other, but they gin up the complaint with the Civil Rights Commission so that you're discriminating against me. My neighbor's after me because I am. Not because you're a miserable SOB, but because you happen to be a member of a protected class. So I want you to make sure that's part of the takeaway. The bad news is people who are going to file these complaints are going to, and again, the bar is set pretty low.
I have two questions. One, does this apply to all HOAs and condos, or just those that have significant funding with federal money?
Nope, everybody.
Everybody. Secondly, I lost an argument with my board. I wanted to adopt a couple rules that said discrimination is illegal, and we don't,
You should have an anti-discrimination policy. I don't know why you lost the argument. You shouldn't have.
Well, the argument was better not say anything than.
Well,
But,
I'm not sure I buy that, but okay.
And then announce to the community that such behavior is illegal or whatever. Does that protect us?
Well, it's just like putting on no trespassing signs in front of the stormwater pond. Is it bulletproof? No. But does it help? Yes.
So you would recommend something?
Yeah, I mean, we're preparing those quite often these days just because of the situation. All right, so to this lady's question, what are you supposed to do? Well, the HUD regs specifically, conveniently, don't tell us exactly what we're supposed to do. But the first thing that we have learned that we must do is if we have the two owners in the fight over, and I could tell you, I don't know if I have time to tell you a couple of anecdotes, and I usually don't get through these without telling at least one story. But put it this way, let's say you've got the noise dispute. You're probably going to have to mediate that. You're going to have to sit down with these two people and try to mediate. They try to get them to come to a resolution. And I would suggest to you that the process of going through the mediation is more important than getting a successful result. You obviously want to get a successful result, but if you can't, at least you've shown that you've done something. You also may have to hold a hearing. You have to send out a cease and desist notice, hold a hearing, and find somebody. And you don't necessarily, I mean, it creates a Hobson's choice for associations, because this law was written with landlords in mind, right? Not community associations. This puts community associations in the untenable position of saying, okay, I can get involved in this litigation between these two people, or if I do nothing, I can get sued under the Fair Housing Act. Now, those are two terrific alternatives.
Does this legislation or this directive differentiate between actual homeowners versus tenants?
No, it does not. But the Fair Housing Act applies to occupants. Yes. All right. So this is what we're trying. This is the things that we have all come up with that we think we should do in these unfortunate situations. We're going to mediate the disputes. We're going to send violation notices.
Has Secretary Carson said anything about that?
He's still asleep.
He's in surgery right now.
Well, I mean, and this came up at the end of the last administration, and I don't know if it...
Oh, no, I didn't mean to be so glib. But I think maybe this goes away in this administration. Maybe by the time, there's a chance this administration might get rid of this. I'll keep my fingers crossed.
We haven't heard anything...
No. They haven't drilled down quite this far yet, but hope springs eternal. All right, so if necessary, I talked about this, we hold due process hearings, suspend privileges, seek injunctive reliefs. So, and we have to pay attention to new developments in this area as we'll get these decisions. I tell you, I have 2 cases going on. We'll get these decisions over time, which hopefully will give us some kind of guidance.
It's nice, 5 contradicts with the other laws of Maryland.
Wait, say that again?
5 contradicts with the laws of Maryland just passed.
Well, let me tell you, that's why we're so busy.
When you're talking about mediation, is that an informal kind of mediation, or do you need to hire a professional?
That's a good question. The ones that I've done myself, and I've had the parties consent to do it. There's certainly an option to hire a professional mediator.
For those of us who have ACM, is there, can I make a suggestion that provide a framework or recommendations that we could put in our bylaws, if we can now amend them, that alerts all the new residents or purchasers and so on that this is the position our association is going to take in hostile environments? Because I don't know what words, but I think we need a leg to stand on to begin with to say, hey, we're not going to put up with this. Whether you're a protected class or not, we're not going to put up with this kind of environment. So that would be something that would really be helpful to get that kind of wording.
I agreed. I mean, these cases can be big money damages cases
well,
too.
That's why we need something to protect ourselves up front to say we're just volunteers.
We can certainly publish anything y'all want to publish, as they say, but I think it's actions as well as the words. I think we can't send out a letter saying we don't discriminate against people.
Well, no, I mean, you need to come up with a policy, and board members really sort of need to be trained.
I want to be able to say, if this goes on, I'm going to fine you $1,000. I can't do that right there. But I don't even know if I can do that. If I have some leverage financially, I could easily tell people, this is what we do.
Anything like that is subject to a reasonableness standard. But
Well,
yeah,
I would assume, you guys correct me if I'm wrong, but if you're going to take action as a board against someone who you believe is doing something to somebody else, harassing someone else, then you're limited to what you can do in your documents.
And the provision you're relying on in your documents is the one I spoke of earlier, the nuisance
provision. This doesn't give you any super powers to deal with people who are nasty to somebody else.
You have to rely on the nuisance provision.
So you're saying I can't, now that I'm aware of this, that I can't go back to our association and say, here's some good wording we can put in our bylaws to protect us.
I think you could probably, you could add to that nuisance provision, you could add harassment to that nuisance provision. I think you could do that.
Right. And there are a number of groups out there. Of course, the attorneys do an excellent job. And there are other groups as well that are nonprofit groups that are set up by the district court that deal with conflict resolution deal with special issues like
I
this?
think she's asking as a proactive thing, if
Yeah.
there can be some kind of verbiage created that can be inserted
Yeah,
in the
you
bylaws
can.
that would cover the association saying that they are not going to tolerate this type of-
You're going to do something in that, remember I was talking about that nuisance provision, you put something in there that equates harassment with nuisance. So you have a cause of action, you have the ability to go after somebody who's harassing. Now, is that going to be bulletproof? Probably not, but it's something. It helps. I mean, again, when I say the bar is low in these cases, I mean the bar is low. Anybody can send something to the Civil Rights Commission and say, I'm being harassed and the association hasn't taken prompt action. And if there's any takeaway here, it's you got to be aware that this situation exists and you can't bury your head in the sand if it does exist. If you know about it, you got to deal with it promptly. The word prompt is all throughout these rules, and you can't hide in the sand.
You said earlier, in answer to a question, that this would apply to homeowner associations like single-family homes.
Mhm.
I know anything is possible, just like you were saying earlier. You've seen it all, then you see something new. But given anything's possible, is it reasonable that this would, if it's a homeowner next to a homeowner and it's all private property surrounded by county property, that this really would, in your experience, get the homeowners association? Would the homeowners association become
All right,
involved?
this is, you get the gold star for a really good question, and I'm pretty much out of time. But let me answer it this way. There's a case in Maryland, an appellate case, that said, in addressing your issue, 2 fee simple lots with a fence between them, 2 people who hated each other's guts, taking garbage, throwing it over the fence, pretty horrific facts. And the court in that case said, on summary judgment filed by the association, you don't have any responsibility in this because these are 2 private homes. There's no association property involved. There's no duty. There's no authority, word I've been using throughout. You don't have to deal with this. That case, I would suggest to you, is moot as a result of this legislation. I think it's a dangerous game for the association to play, to just let that go. If someone is suggesting that the garbage is being thrown at me because I am protected class. Okay. All right, I think I'm out of time, but I'll be around at the end to.
You have to prove that.
to-
Now, you have to
Actually, it's more. I hate to be glib. The way these things are done. Remember, who's the Civil Rights Commission? They're employees of the state. Their job is to find discrimination, more or less. So it's more. I think the burden is almost on the association to prove there was no discrimination, rather than on the plaintiff to prove that there was. That's not quite true, but you don't want to even go there. You want to not be in the Civil Rights Commission at all. All right, thank you all. I'll be around for.
We have the bin up here for seminar questionnaires and comments. That's where you could give your input to Vice President Jones on their accounting program we're going to do next month. And so we really want to hear from you, and so that's a good place. So if you could remember to do that at the end of the program. I want to thank Ray Vaya for his contribution to today's process. There's been some interesting court cases lately, and of course the HUD program and a little bit of legislation. And next, our next speaker is Ursula Koenig Burgess. Did I do that right? Okay. Who is with Rees Broome, and she has spoken to our group before. She is an excellent community association lawyer, and great with collections and overdue payments and all that good stuff. And she's come up here from the greater Washington area to explain stuff to us. So with that, I'd like to ask Ursula if she could come up and we can start this process.
Great. Hi. I was joking earlier when I got here that on days like this, I'm glad I don't have to wear pants. Right? Menfolk have to wear pants. If Ray had been up here without pants, right, this would have been a very different seminar. So we're going to make sure that we get you out of here by 6. Ray did cover some of the stuff that are in my slides. The reason we're overlapping is because we're just so excited that something happened this year. Last year, nothing changed in the condo or the HOA Act. You saw our books out front. Literally all we did was change the cover for the next year and move on with our lives. So it's very exciting when things change, because then we can talk about it and pontificate and tell our clients what it actually means. Most of you will find that extremely boring and useless, but we thrive on that kind of stuff. So amendment of the governing documents, this is what he spoke about. The one thing I was going to add at the bottom of it is there's really hinky language that says it doesn't apply to village associations or associations part of a homeowners association. So that may be an exclusion for you sub-associations. So if any of you are in a sub-association that is part of a master HOA, take a second before you start trying to amend your bylaws with 60% vote, because there may be an issue with that. Inspection fees for the inspections of lots for resale. So this is a change only to the Homeowners Association Act. So the Homeowners Association Act is, for the managers in the room, and those of you maybe who have served on both types of boards, is very different from the Maryland Condominium Act. In fact, you might think they're from two completely different jurisdictions. They're so different. One of the areas they've differed a lot has been in the resale. We have been trying to work slowly but surely to normalize them a bit, and this is a step in that direction. So what this says is if your governing documents require an inspection of the lot as part of the resale certificate, that you can charge them a whopping $50. Wow, I know, 50. Condo X says 100, so definitely still getting shortchanged on that side, but it's still something, and it is only permissible if your governing documents require the inspection. So that's key. Mel and I were chatting earlier that recreationally, I guess he went through a bunch of governing documents, which prompted me to advise him to get a hobby, to see if they actually had those requirements in there, and they couldn't find it. So it may be that it is not in your governing documents that the inspection is required. So take that first step, see if it's required, and if it is, you can charge a whopping $50. Yeah. Hopefully we're pushing next legislative session to get it up to $100. So by a bit of background, one of my colleagues in my firm is the vice chair of the CAI, Maryland Legislative Action Committee. That is a national committee that people are appointed on. In fact, the chair has been a homeowner member, not a lawyer, not a business partner. Very exciting. And we have a professional lobbyist. I'll give you some information about that at the end, but what they do is they work with the lobbyist when these bills are milling around in the background, pushing to get things to either go through with amendments, to get things to die in committee. It's a very helpful group, and it gives us some ability to sort of know what's going on legislatively. But the sense is that they're going to bring another bill back this coming year, 2017 to 2018, to try to up that. Keep our fingers crossed.
Ursula?
Yes.
What's the purpose of such inspections? To identify violations?
Correct.
So if you have a pretty good system of taking care of violations, this would not be...
Well, so that's a good question. As it stands right now, the statute says that the seller has to disclose any violations to the purchaser. Right? How many of us are going to disclose all the violations when you got a contract for sale, right? So this says basically if your documents require an inspection by the HOA can now recoup that fee. Right. I mean, it's not much of a fee at this point, but that's the point of it. So really it's that reliance to kind of take a little bit more control to indicate if there are violations, because you know how many times is something sold, there's a violation and the seller didn't disclose it to the purchaser, right? And then you have to give them the bad news that it's their problem to fix. Yes?
I thought as part of a sale, you're required to have an inspection.
For a condo.
The closing.
Condominium.
Even condominium.
Condominium you are, not an HOA. This is only for homeowner associations.
When I sold my house, I had to get it inspected.
Maybe your governing documents in that one said it. I mean, usually the seller does it. The seller's supposed to do it by law.
The person who's giving the mortgage requires that.
And maybe, that may be a requirement as well, but this is only dealing with the association has to inspect it. So, but you're right, you've got overlaps of real estate laws, real estate disclosures, things that fall into place that have nothing to do with our our area. Yes?
So I am in an HOA, and so is a resale inspection required for an HOA or no?
It's currently written that the seller has to disclose violations to the purchaser.
So that's all that's in the law today. So we've been doing resale inspections.
But that's good. I mean,
Yeah.
you want to control that, right?
But it's not in our documents.
Right. And that's okay. I would rather that you do the inspection because, I mean, how quickly do things get fixed once you put them on that resale disclosure package, right? Indicating there's a violation, it gets
Right.
fixed, they want to close the sale.
But it sounds like we can't enforce that.
No, you can. That's fine. Nope, I have no issue with you doing that. It's just legally, you don't have that obligation to do it unless your governing documents say it.
But if it's not in your documents, do you have the right to do it?
Yeah, absolutely. I mean, you're providing the resale disclosure with the financial information, the assessments. If you want to add language if there are violations on there, absolutely.
Is this condo or did you say condo HOA?
We're only talking HOA right now.
Okay, because he's also an individual house owner. I'm an HOA with individual homes, not a condo.
Correct.
association.
Correct. Right, that's what we're talking about. Homeowners associations, they're treated differently than condos. Condos, you have to do the inspection. Condos, you get $100 for the inspection fee of the condo for the violations. That does not exist on the homeowners association side. What this law now says is if your governing documents say the homeowners association must inspect for violations and provide that in the resale disclosure, you can now assess a $50 charge for that inspection. If the governing documents are silent on that requirement, you could still go do that.
Well, they are silent, which
Right.
is just puzzling why people are ordering resale packages. when
Well, the
our
resale
documents don't have
package,
anything
right.
about it.
So the resale package has to have certain other things. Copies of the governing documents, financial information, budget, that type
But
of
the
stuff.
inspection is part of our resale.
Right, which is fine, but it's not required. The seller has to disclose it. And if you're doing it instead of the seller having to do it, that's fine.
I'm still confused, maybe I'll talk to you after.
That'd be good. Okay. Yes, sir.
Does the $50 fee, is that separate from the resale package?
Yes. Yes. Just an inspection fee. Yes.
But there's an overlap of laws with the mortgage and realtor regarding home inspection. Could in theory this person's house be inspected more than once?
Absolutely. Oh my goodness. And the buyer's probably got their own person in there inspecting it. Yeah. You have a whole parade of people into your house. Foreclosure notices. So this is what Ray touched on a bit, where we got some good news. So generally what happens when a lender files a foreclosure action, it is filed in the circuit court of the county where the property is located, right? So we go in as lawyers, we see that it's been filed, we see that they have filed the mediation notice, loss mitigation, bing, 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 and then there's a void. And then sometimes we get a notice that a foreclosure sale has been scheduled. And then we spend 2 weeks after the date of the original sale chasing down the attorney's office trying to find out what happened, right? It's a giant pain in the butt. So this law is helpful. Now, it was funny, I was joking earlier, I was going to call this the good, the bad, and the ugly, because each of these laws that have passed have some good things and some bad things and some ugly things. So the good things about this is they have to file within 7 days of filing the actual foreclosure action in circuit court with the DLLR, the foreclosed property registry, all of this information. So whether it's vacant, last known address of the property owners, name, address, and telephone number of the person who is authorized to maintain the property, if any. So it's good information, and specifically, if we request it as a condo or HOA, they are able to give us all of this information. Specifically. Now, I say that it's good, and it's bad. So what's going to happen? We don't know if the unit's vacant. Oh, good, because we don't either, but we think it might be. We don't know the name, address, and the telephone number. They just regurgitate the property address, right? And certainly there's no obligation if any of this is updated because they're contacted by somebody that they reach back out to us. So it's good that it's something, it's more than what we've had, and it's very early on. It's when they file the lawsuit to foreclose as opposed to later. So What's interesting is this doesn't come into effect till October 1, 2018, because as you might imagine, there's some administrative things that they're going to have to do as far as how they're going to maintain this. Our concern, of course, is how is it going to be searchable? Is it going to be by street, for example? Is it going to be by a parcel ID number? What can we do as council to search this quickly to find out if something has popped up on the registry, right? That's the ugly. I don't actually know what's going to happen with it and how user-friendly it's going to be. But it is something hopefully positive. I think you had your hand up first.
When it's foreclosed on, is the lender now obligated to pay any back assessments?
So this is not foreclosed upon. This is lender has filed a lawsuit in the Circuit Court of Baltimore County for permission to foreclose.
Oh, this is just permission? This is not-
Correct. So this is the first time that we have the ability potentially to know that you could search perhaps a street name and see things that have popped up that a foreclosure action has been filed. Because does anybody have the free time to get on the Maryland Judiciary case search and search every owner's last name once a week, right? Nobody's got time for that. So hopefully if it's searchable by address, we would be able to do that and come up with it quickly. Yes, sir.
I was going to say, we see this type of information posted on vacant units, so there must be other laws requiring to post this stuff.
Usually when I've seen that, it's been with winterization and access and things of that variety.
Yeah, FHA,
Mhm.
FHA.
And it's usually one of those really squirrely fly-by-night companies where the people come in and winterize, and then you change the locks because they really aren't supposed to be in there, and then they break the locks. And
They're different guys.
Yeah.
It seemed like they're from different places.
Correct.
Right across from me, there was a unit. In fact, I kept seeing these people checking everything, from scratch every month.
So hopefully this information about who's authorized to maintain the property is going to save us that headache as well, because I can tell you that is I've had plenty of those guys that we've confronted, and they give you initials for companies that don't exist. You can't find them. So it's good. I'm not willing to go that it's great. It certainly has its limitations, but it's coming. So hopefully we will be able to use that system well, that they'll set it up well. So watch for more information coming out about how that gets set up.
I just mentioned it because this stuff posted on it kind of gives you an idea. Maybe there is something in this registry. You go search it.
Right now, the registry, you actually have to upload a copy of your notice of intent to foreclose. And you have to give them some details out of that. So we have to do that as well. As condos and HOAs, when we go to foreclose on a property, we actually have to upload that to them as well. So there's some limitations on what's required. They're just enlarging what they have to put in there.
Condo, we don't foreclose anything, but we'd like to get paid past assessments.
We would all like to get paid our past assessments.
Thousands of dollars.
Correct.
Tens of thousands of dollars.
So the second foreclosure notice that they have enacted now is about notices to us. So usually we get a notice as a lien holder on the property saying that an auction's been scheduled. What we don't find out is if it's been rescheduled, if it's been canceled, whatever. So this law states that if it's canceled or postponed, within 14 days of the date of the sale, they have to notify us. Do you know what that doesn't say? It doesn't say if it sells that they have to notify us who the purchaser is, right? So you don't get that letter, you're still back on the phone calling to figure out who the owner is so that they can be assessed, the assessments coming forward. Like I said, the good, the bad, and the ugly. It's something, it's a start, but we're still going to have to pick up the phone. Yes, ma'am.
There's a foreclosure. I know last year or year before, there was a $1,000 limit to the fees and things. When it's foreclosure like this and someone else is purchasing it, can those fees be added to the cost of the property being purchased?
So the law about the priority lien only applies to mortgages I think that went in 2012, 2011, they're later, right? And that would be something that I believe the foreclosing entity pays. Usually it's the bank. How they
only pay $1,000 if that's the max.
Correct. I think it's $1,200 actually. And how they pay it, they work it out in settlement. We don't get in the middle of that.
But there's no way that the association can try to recuperate any of those colors.
No. So if you look in your governing documents, they all say that owners are responsible for the assessments during the time that they are the owner of record. right? So then you have a foreclosure. That bank was not the owner of record in all those years that it was, ramping up. So there's no way to put the mortgage company on there. And that makes sense because think about it. We were just talking about the inspections, right? You have a whole bunch of people going through the house and inspecting it before they buy it. That includes the mortgage company. The mortgage companies are looking at the financials of the association, especially if it's an FHA or VA-backed mortgage, right? They're looking at all that information. They want to know if we're going to amend our bylaws, right? Ray talked about that. We have to send notice to them if we're going to do a material change. And it's because they have a security interest in this. And so if we were to tell the mortgage companies, if Mr. Smith doesn't pay his assessments and you foreclose, you have to pay all of Mr. Smith's prior assessments. They wouldn't get a mortgage on that property, right? The governing document said that. We wouldn't have any lenders on any of our properties. So the documents are written in a way that make the lenders comfortable to loan money and have security on the unit or the house.
So then, there's no way as the condominium association or homeowners association could sue the people who did not pay.
Oh, absolutely.
There is.
Oh, absolutely. So, and I don't want to go too deep into collections. I could talk about collections for days. Once you have a judgment against somebody, it gets reported to the credit bureaus, and you renew it in Maryland every 20 years. So say 40 years down the road, you got some 20-something-year-old who buys a house underwater immediately, it gets foreclosed on, you get a judgment, it sits on their credit report, you keep renewing it. 25 years later, they've gotten their act together, they want to buy a car, and it hits. That's a very nice passive way to collect it. You never know. Judgments come up. People want to get a security clearance in the DC area. They'll call you to get a payoff. They want to pay it because of that. Having debt hurts you to get certain security clearances. So absolutely, you should be pursuing them. And I'm a firm believer if it's high enough in a condo that I would do a sheriff's sale to foreclose on it, have the condo association buy it and rent it out.
They got the money.
Yeah. And again, I could talk about that for days. Yes, ma'am.
Totally illiterate, okay? Again, HOA, individual homes, the association has liens on each of the houses. I forgot what reason it is, I don't know. So the house, the owner is in arrears 6 months of association fees, on the property. It's now up for sale. How does that work with the association getting paid, if at all?
So that's a different set of facts than what we've been discussing. That is a third-party sale. In a third-party sale, the resale disclosure documents would disclose the unpaid balance, and then it would have to be paid at settlement. Otherwise, the new owner assumes the debt. What we've been talking about is foreclosing, right? So that person is the owner of record. They're sitting at closing table. They owe up to that point, and there's no way to get around it unless the new owner wants to assume it. And sometimes there are some governing documents that have some wonky language about that says a new purchaser shall be jointly and severally liable for the assessments if it's a third-party sale. It's not often, but I have seen it. I haven't enforced that because it just creeps me out. But it usually gets paid when it's a third-party sale. So some bills that were proposed, Ray talked about this, the car charging. I do think it's coming back. I do think it's going to come back. I actually think car charging stations are a good idea. I don't want the big surface lots with cords all going in. So I think it would be good to have legislation that prohibits, doesn't require us to do that if it's an open surface lot, but a lot of your garage facilities, it's actually quite simple to do. And technology has come forward so much with the charging stations that they're actually, smaller than this podium. Some of the ones that I've done for some of my clients. So I think it's coming. The big problem with this was like the antennas. It literally gave us very little to regulate on it, which was not appropriate. And so hopefully we can work it down to something better. Your mandatory reserve studies. I do think this is going to come back. On the other side of the river in Virginia, it's mandatory every 5 years. The good news about that is it makes your life budgeting a lot easier when you say you have to raise assessments and the board says, here's our reserve study, we are underfunded, now you have support for it. So I think it's a good thing to use for budgeting, and I think you have a fiduciary duty anyway to make sure you're budgeting appropriately. So I think reserve studies are good. The problem with the bill is that it was It was very sort of generic on how it was written, on who did the reserve study, for example, and what kind of requirements need to be in there. So I think it's just going to get retooled and probably going to come up next year.
But these are very expensive. I mean, we have a condominium, now has 28 units, 27 units. Your minimum of $5,000 for that study. That
Correct.
becomes quite expensive when you're looking at your condo fees as a whole.
Do you want to know the trick to that? You ready?
I'm ready.
You sign a multi-year contract with a reserve study company, because the second year they have less work to do, the second time they do it. And the third time they do it, it's even less work. So you will actually pay less if you sign a multi-year contract. Yep. Learned that trick a while ago.
5 years.
Yeah.
They don't have to reinvent the wheel every time.
Correct. They don't have to come in and redo everything, right? They take everything you had. They're already familiar with your accounting systems and your budgeting and how all that's done. It's a lot less work.
Well, they did that for us, but it didn't change what's on the place.
And then you're working with the wrong person, frankly.
It's going to depend on what you've got. You could have, it could be a small community, but you could have a lot of structure and a lot of interior improvements that have to be considered. So we've seen them as low as $2,000, $1,500 to $2,000, and as high as $5,000 or $6,000.
Bid it out. When in doubt, bid it out. What can you do to help? So I spoke briefly about the Maryland Legislative Action Committee. That is a national committee that they do employ lobbyists. They do take donations. The address is on here. It's in your documents. I can certainly give you more information on it. With that and having a professional lobbyist, we're up against the real estate lobbyists. We're up against the banking lobbyists, the mortgage companies. Like, we're going up a hill in the middle of winter and, molasses. So any bit of money that we can kick in to keep our lobbyists up and working harder and pushing on these things is good. Last year, the LAC actually won a national award for advocacy because nothing passed in affecting the Condo and HOA Act. They did such a good job with the lobbyists. So if that's something that you all are interested in doing, what they recommend is what they call as $1 a door. So you donate $1 for each unit or lot in your community to the LAC. And you just make it an annual thing in your budget, and you're doing some good to help keep legislation and things in check to help you all. The other things that you can do that I actually think are more meaningful than money is you can contact your legislator. When we send out alerts, they do come out from time to time that some bill is on the floor and we need everybody to jump on it. And that's going to be more effective if you have invited members of the General Assembly who are in your district to your events and you start establishing a rapport with them. So I have an association that every year has Kumar Barve and Jim Gilchrist and a number of other delegates and senators who come. In fact, one of them lives in the building. And the year that the pit bull mess came down and they didn't fix it, I literally stood there and yelled at them for 10 minutes before the annual meeting started because it was ridiculous that they didn't take care of that in the General Assembly. But it's been helpful to have that relationship. When something comes up and they're on one of the committees or someone who's considering it, I have no problem picking up the phone and calling either one of them. So bringing them into your communities to see the good of community associations and the positive side of it, and getting in their ears so that when you pick up the phone and call them and say, hey, Delegate Smith, it was really great to see you this past summer at our ice cream social. We know this bill is pending. It's going to have a negative impact on us. Do you have a few minutes to chat with me? You're a constituent. That is going to work more than anything else. I mean, I'd like you to give money to the lobbyists, but having that relationship is going to do a lot more. So if you really want to be involved and to help, that's the way to do it. Or you can do it like some of you, all right, one of you in the room over there who actually goes to Annapolis when we are in session and we need help and we need someone to testify about why things are so big and bad and awful for bills. That is something that is far more meaningful than the lawyers. I mean, Ray and I could go there and they're like, oh, it's just those lawyers. And so if you have that inclination that you want to help and be involved, even if it's you just want to make one phone call or send one email, that's great. If you want to go to Annapolis, you could carpool and give testimony, and I think that would be much more powerful in impacting some of this. So keep your eyes open when you see alerts that are coming out on big things like this. We can always use the help. Yes?
Two questions.
Of course.
One is, how do we get on that on their list or receive alerts? Just by writing them or asking them to put on a list?
So usually I get it from CAI. So how many of you are members of CAI? Oh, all right. So I'm going to tell you all a little secret.
Excuse me, what is that?
You don't know what CAI is?
No.
So CAI is the Community Associations Institute. It has over 34,000 members that are managers, homeowners, and business partners. So the lawyers, your tot lot chip providers, your dog poop picker-uppers, your geese that chase off the ducks out of the lake, they're all members. It's international now. We just opened a chapter in the Mideast. We're opening a chapter in Canada. We're working our way into Australia and Spain at this point. The entire goal of the Community Associations Institute is to assist in the good governance of community associations. Their national headquarters are in Falls Church, and that is their entire focus. So if you get on their website, cai.org is their national website. You'll see they've got legislative action committees and political action committees to assist in making donations and legislative. The good news is effective October 1, has not been announced yet, is they have reduced the pricing for homeowner board members. So previously it was based on the number of people who joined, right? So if you had 3 people who joined, it was X number of dollars. If it was 7 people, it was X number of dollars. Effective October 1, it is a flat rate. And you can have up to, as I understand it, about 15 people who are members. So you can add your board members, your architectural people, your social committee. You can add a whole bunch of people. So you will see announcements that are going out about this. Do not call CAI and tell them that Ursula told you that. I am on the national board and voted for this change in the membership structure. And they're all going to yell at me if I tell them that I told you how to do it right now. So wait for the rollout. If you are not members, do it October 1 because it is now the price is the equivalent of 3 people. So you can have your entire board on there for the price of 3 people, and it's only like $200 for the year. So you'll get the alerts, you will get the magazines. We have a national conference that will be, some of you go to the local conference down at the convention center every year. How many of you go to the conference up in Baltimore? How many of you just want to go to the pool right now? Right.
Are we talking about the expo?
Yeah. So there's what you're going to have next year. There'll be 3 conferences and expos here, all with educational seminars with a track geared completely at homeowners. The first one will be in the Walter Wilson Convention Center downtown. The second one, which is the national conference, is coming to DC next year and will be up by the zoo. And then the third one is the one run by the Chesapeake chapter usually it's in September or October. Great opportunities. If you're not going, go. You'll learn more about the issues of what's going on and how you can get involved to help. And you had a second question. Did you see that? I remember that, and I was coming back.
You can see the level of awareness here, and I think it's very common because we have no organization just for HOAs or condos. Would you talk a little bit about the build out? I've been interested in that. We talked about earlier the requirement that we register in the state, the attempt to create a registry for. Sure.
So initially, the genesis is, so the CCOC that Ray talked about is a commission out of Montgomery County where when you're a member of it, you have to register, you've got to pay a certain fee. And those fees help keep the CCOC running. There's a lot of political stuff that I won't bore you with the background, but if you are in Montgomery County, the city of Rockville, and the city of Gaithersburg, right, then they just opt in, they have to pay the fee and they have to be registered. They want to do it for the state of Maryland, and they want all of the associations to register and pay a fee. The big problem that I keep hearing about it, of why it's not passing, is there's no infrastructure in place to deal with it. So think of all the community associations that exist in the state. You can't just tell Bob part-time, in the Office of Consumer Protection to deal with all these registrations, right? It is going to be a much larger job than that, and my understanding is they just lack the funds and the infrastructure to do it, which is what's keeping that from really getting any traction.
Is this the organization, I'm confused between this and I thought there was another organization we were trying to have legalized in condominiums would be controlled by another group. Like, here, all the condominiums would be under one rule. I can't quite, it was something we got from ACM about something in the legislature, and I don't know, that was what they were.
I think that's what they're talking about, correct. That everybody would have to come in and,
What is that group's purpose?
well, it's the state of Maryland.
Well, what is
No,
that?
the registry, what did we
What
get?
is it?
What do we get if we register?
Well, we don't, that's one of the problems I think the people who are not supporting it have, is it doesn't really, it's not clear as to what this registration would do. And a lot of people were afraid to give that kind of personal information or community information without knowing what the state's intentions
Right.
are.
Well, the question was, what is the group's responsibility? What is their focus? What is their mandate? What
We
are
don't
they
know.
supposed to be?
We don't know.
doing?
That's the problem. They don't have the infrastructure, anything set up. It's simply, we want you to register and pay us a fee, and then what happens next, and then we don't know. And so that's why it continues
So
to
the
fail.
question is, do they, you know, if they want to create something similar to Montgomery County, well, they have very specific responsibilities and they mitigate issues and they pass legislation. They got people who run around in cars and, I don't know, checking things out. But that's a different, that's where they think it could build to. The people are afraid of creating another bureaucracy.
Well, you don't need any ordinance.
I mean, I think also, so what happens is oftentimes people are looking across the river, right? So in Virginia, they have established a common interest community ombudsman where people can file complaints that the association is not following the law. So it's a very limited little area about following the law. And so everyone has to register. If you go on, so the DLLR in Virginia is DPOR, Department of Professional Occupation Regulation, and you can look up community associations. And they're listed, and you have to register, and you got to file an annual fee, and that helps fund the ombudsman's office. So we know where those fees are going, but that took years to come into place. They basically enacted a law that said we're going to establish an ombudsman. Now you have to establish the regulations, and that took a few years to actually come into place. And I've actually found it to be marginally helpful. We get some opinions from there that are helpful, that support our position, and then when an owner is pushing back on something, we just send them a copy of the determination from there. So, but they're just not there yet in Maryland. But Maryland has some things they do better. Like the Condominium Act has language about the dispute settlement resolution. And Virginia doesn't have that. The process is set out nicely in the Condo Act. It's not always the best process that people are happy about, but it's a process, and we just lack that on the other side of the river. So it's interesting, everybody they look back and forth to sort of see what they're doing, and then someone gets the idea, well, we had to take what they're doing and try and do it over here. So I do think we see a bit of that as well. So I'm done on time. Do you see that, Ray? Do you see? For the 15 minutes of questions and answer.
If you into that, you got other issues you want to discuss?
I was going to mention, how many of you, when the pit bull issue came down saying that pit bulls were per se dangerous, enacted a rule banning pit bulls from your association? Okay. So there was, and I don't want anybody freaking out because this has been fixed, but there was a very bad case that came down saying that pit bulls were inherently dangerous, and a pit bull on property who hurt somebody, the landowner was liable for any damages. So it was a very bad case, because think about it. If you got a pit bull sitting in a vet's waiting room and hurts someone, the owner of that building would be liable because there's a pit bull in there. It was a terrible decision. It was revised. It didn't really help. The General Assembly ultimately fixed it, but it took them, they had to get through 2 legislative sessions to do it. So some of our associations enacted rules banning pit bulls. And so some of our associations are asking, should we be revoking those rules at this point in time? So I just want to see if that was something that you all were experiencing, because we're getting some of those phone calls right now from people. But if you're not, that's all good. And don't enact a rule banning pit bulls. Bad idea.
Exactly.
Yes, ma'am.
So it came up just recently in a board meeting about a week and a half ago, where people are getting wrong information, thinking that there is still a pit bull law. And it's difficult to explain to other board members who really are not up to speed. So it's a whole lot easier for the people that are active and very involved and learn what's going on to help the other board members to learn. And so, I'm very fortunate. First of all, I'm a real estate agent, so I'm involved with legislative alerts. I'm If I have a problem, I call Bill Costello, I call the lobbyist. I had a problem with Anne Arundel County and Baltimore City, where our delegate actually put into place a parking lot that only affects Baltimore City and Anne Arundel County, when we could not, as a condominium association, and I'm in a townhouse condominium, he couldn't tow. There's a tow. But he decided to sign, but he didn't realize the effect of it. He thought it was parking lots, restaurants, other people, but it affected us. So I went to Bill Costelli, and I went back to the legislator, I was talking to aides, I was talking to everyone, trying to get things resolved. So sometimes it's a little bit hard to walk through all these things.
Correct.
So I'm a licensed insurance agent too, so I can help people on the board. But, just like when I was involved in CAI, I've taken classes, it helps if we go back to our boards and educate our other board members who don't come to these things.
Correct.
And so I think this is a wonderful venue, and I really appreciate that it's offered, because it does help us. And I sign up and I answer all the time legislative alerts. So if we had something like that, I think it would be very helpful. Our community manager is fantastic. We absolutely love her. We're really fortunate that we have her. So I think something like that.
You're one of our clients? Just checking.
You can pay the $5 after.
And it's really interesting how powerful it is, the legislative alerts. So CAI does a national advocacy summit, and I did it for the first time last year before, and that was when they had the radio tower antenna stuff pending. And we were talking to an aide who said they had received 6,000 emails from the radio antenna guys. And the emails were very similar. Clearly someone had said, this is what you ought to do to support ham radios. And they said, well, we haven't heard from a lot of your people. And we're like, but it was 6,000 of a canned email, right? But it was, we managed to get it where we needed it to go. But it was very interesting to hear how they had that. And when we have just members of CAI, 34,000 people, you'd think we would have eclipsed that quite easily. So I think CAI does a good job with them now. The alerts come out, and you literally click on a button, and it sends you to where you need to go, and you can type in an additional message, or they have one in there for you, and you click send. So they've made it with the use of technology very easy. And what I can certainly do is send it to Mel when I get them to make sure that...
We get them, we're members of CAI,
Right.
and I'm a member of CAI. And so we distribute those issues that come with that. But one of the things you're talking about, in your case, for example, CAI does not reach down to the local level. So if it's a statewide issue, then yes, they do have the team in place. But if it's Baltimore County or Baltimore City or whatever, they're not going to, they don't have the personnel, or they don't have the people on board to do that. They don't even have a committee structure to review that. I don't know about the Washington chapter. We just joined Washington. Washington represents Prince George's and Montgomery in our state. But I don't know that they have committees.
Yeah. So we do reach out locally. I mean, it's got to be an issue. So Montgomery County, the government of Montgomery County, God help you. They're already looking at the electric charging stations issue. They're going to come in and tell us something about that, I'm sure. They have laws in Montgomery County about terms for board members, that they have to be staggered. They have things that override our governing documents. My poor clients in Montgomery County have an extra layer of stuff. I have to say, no, that doesn't count either. We have to go to this. So it's possible the localities are going to start doing this. If the electric charging stations doesn't pass on a state level, it would not surprise me if we start seeing the localities. Yeah,
well, Elon Musk has a lot of money, and you may see that. But I think one of the things that's wrong, I think, in the Chesapeake chapter, because it's the biggest chapter, it represents all the rest of the state, is it does not have a local component at all.
Yes, ma'am. I'm sorry.
I guess the new item is B&Bs. I bet that on the news.
Airbnb.
And my other subject is solar panels. I understand we cannot regulate, but I noticed that these high-end communities, i.e. to me is $500,000, $600,000, $700,000 homes, they don't have those solar panels on the front of the house.
So you can regulate them. There's a law on it. The books that you all have, there's language about the solar panels in there and how you can regulate them. I think it's just reasonable regulations, right? Yeah. reasonable regulations on it. So you can't require them to put it, for example, on the back of the house if that doesn't get enough sun. Then it's kind of like the satellite dishes. Then you have to allow them to put it on the front.
Right, so it's gonna be the same thing with these electric plug-ins for cars.
Likely, I think it'll probably be very similar. Now, the short-term rental, the Airbnb, I mean, that's huge everywhere right now. I mean, even on the national level, they're watching that. So Airbnb reached out to CAI National and said, we got to sit down together and tackle this issue together. And they were like, you need to go away. We do not want to talk to you at all. Like, it was laughable that Airbnb actually reached out to them for it. And, you know, you hear it like the locality, as a TOP was talking about, Fairfax County is now, which I think could be very helpful for us, because Fairfax is going to consider how many people you can put in there, what sort of parking you need to have, right? So yay for our developers, right? 1.5 parking spaces. Oh, that's not going to be enough for you to do Airbnb. I'm sorry, you can't do it in this area. So some of the localities might actually be helping us in that as they're reviewing it. I think Fairfax is going to be a few years off, but it's
Montgomery
such...
County has legislation pending now.
Yeah, they do, and I haven't seen it.
It's been pending for a year and a half.
That might be why it dropped off my radar. So some of these issues, you are going to see them impacted locally as well, which hopefully will be for the better, I hope.
Let me go back to the solar. We have common roofs, but this solar, it's a huge outfit, came in and put a solar panel on the roof of this guy's unit, you know, without anything, well, without any kind of permission or notification or anything else. We're in a process through our lawyers of forcing them to take that off. And also pay for any damage to the roof, our common roof. But the units look like separate HOA units, but they're actually condos. They're kind of inset and different fronts.
So the roof is common?
Common, yeah.
So the board didn't give them permission?
We spent $200,000 a few years ago to replace the junk that developers put on the roofs, the roofing.
Well, I mean, that's on a condominium. I mean, the board still controls the roof on the solar panel.
Correct. Solar panels and satellite dishes. You can't.
They didn't ask, they didn't care. They put, you know, we'll put it up, and anybody complains, then we'll worry about it then.
You shouldn't lose that battle.
This is a huge outfit.
Well, I know, yeah.
Yes, ma'am.
Just to add one thing to that, it is a horrible nightmare for real estate. Horrible.
What, solar panels?
Because the buyer has to now qualify for credit in order to continue the lease. So in addition, so now you're adding more debt, so there's a problem with the loan, the mortgage lender is having a problem with it. And the same thing with how do you replace the roof? You have to take all of them off. So those people are not buying their...
And who's responsible for that? Mm-hmm. That's a company, a national company, and they actually, they signed a long-term lease with the user. And the problem is that when the user sells, then that lease then has to be transferred.
Wow. All right, you have 6 minutes. Yes, ma'am.
I know kind of brushed aside the collection policies and so on. Is there a recommendation or some kind of guidance I can go find what a strong collection policy should be for us?
Sure.
Does that come under rules? Does that come under bylaws? Or
Well, that would typically be a policy, a rule. That's sort of a semantic issue. But you're going to want to have a collection policy. And the most important part of it is to make sure there's a priority of payment. I mean, it's a few things that are important in terms of when management sends a letter, when the case gets referred to an attorney, interest, all those things. A lot of those things are already going to be in your bylaws and would be replicated in that policy. But the most important part is the priority of payment part. You want the association to get their money back first. So, in other words, if you've paid X dollars to a lawyer, if you've paid court costs of Y, you want that money back first before the assessments are credited. So if you went into a payment plan with the debtor, they're going to pay you back first, and then they're going to gradually get to the point where they become current. So that's very important to have that language in there. But you should have a good collection policy and have your lawyer review it. It's a very important piece of your governing document structure.
Well, ACM probably should be able, because they did with us years ago.
Yeah, we have policy. We always recommend that an association develop and have a published collection policy. It's an excellent collection tool because you're letting the homeowner know that this is the sequence of events that can wind up in their offices if these fees are not paid on time.
Is it legal to affix fines to the assessments?
Well, it's illegal. The question is, what does your document say? There are restrictions of what they, in state law as to what they can be. But if you're, we have associations that don't empower the board to charge late fees. And
No, these are like violations.
You can include finding amounts on somebody's statement of account.
Right.
And you can collect that. Typically, your governing documents will say you can collect that just the same way you collect the assessments.
Okay.
But you can't fine on a fine, or you can't bootstrap that way.
Right.
But you can include the fines in the statement of account and collect.
You got 3 minutes. All right, well, thank you all.
Thank you all.